These women and men are relatives of the incarcerated National Unity Platform supporters yet to be freed from the shackles of prison 5 days after the Supreme Court issued a landmark decision that annulled the trial of civilians by the General Court-Martial. They turned up at the High Court Civil Division, accompanied by the National Unity Platform lawyer George Musisi and party leadership, to apply for the unconditional release of the detainees.
They should, after the 4 years they have spent in Chitalia prison, be released in accordance with the Supreme Court decision, since they have no crime they committed.
Why don't they release them since they know nothing about the crimes they were charged with?
There are 15 detainees the families are seeking for an order of the court to have their immediate release. Among the detainees are those who have spent 4 years behind bars following the arrest at the height of the 2020 campaigns. 19 of the National Unity Platform supporters, previously faced with a similar predicament, were released in November 2024 after they were issued a presidential pardon after they pleaded guilty to the charges of treachery and unlawful possession of ammunition.
Please rise to the occasion as civilian courts to fight for yourselves. Because, yes, we are talking about these things in Parliament, the Attorney General keeps confusing us everywhere and that kind of thing. So we are now telling court, please stand up and fight for your authority and fight for your space to see to it that the decisions of the Supreme Court get to be implemented with immediacy.
It is argued that the government's resistance to releasing the detainees creates an awkward state of affairs since there is no valid warrant issued by a competent court for the continued incarceration of the detainees. Concern raised is that the detention could go on without an end.
What that means is that these people can be in that custody for even years before government decides to release them. They are not under the control of any court now. The court which remanded them has no control over them, and their files have not been transferred to any other court. That means they can't apply for bail.
Attorney General Chirwa issued an advisory to the prison service to hold the detainees in custody until a decision has been taken by a competent court.
You can see, for example, the charge of treachery, which is only under the UPDF, and then the other one, unlawful possession of ammunition and all that. So we are saying that these people should be released immediately, with immediacy. And we are saying that right now the Museveni regime is in contempt of court.
Uganda Law Society has also added a voice to condemn the delayed release of those held in custody on the orders of the General Court-Martial.
The end of civilians before military courts, that era is over. But as to whether it gave effective remedies for the victims of a system of justice that has been found unconstitutional, that's debatable.
The court does not say, I have freed, because the case hasn't been heard. They are only saying, bring it before the proper court, so that we hear the case. So we should not misguide the population, Mr. Speaker, by exciting them that now it is a release order.
On Wednesday, lawyers of the veteran opposition leader, Dr. Kiza Besigye, and his aide, Obed Lutale, applied for habeas corpus, seeking to have Chirwa and the Commissioner General of Prison, Johnson Byabasaija, have a day in court to state why the detainees have not been released. Jackson Onyango, NTV.